Hello, my name is Christina Crump. I'm a bankruptcy attorney here in Kansas and also practice in Western District of Missouri.
Hi, I'm Chris Coons, and I am also a bankruptcy attorney.
Today we're going to discuss the differences between Chapter 7s and Chapter 13s.
Yeah, so I will start with the basics, and we're going to start with Chapter 7 today. Chapter 7s are commonly known as liquidation cases or complete bankruptcy or total bankruptcy, but the idea in a Chapter 7 is that you really don't have enough money to repay your creditors, so you're going to file a case and try to wipe the creditors out and start over. And you'll hear people call this a fresh start sometimes. You have to qualify for Chapter 7. There is a means test, and we're going to look at how much money you have coming in the door, whether or not you're over the median income, and try to see if there's money left over on the means test, and also if there's money left over in your regular budget.
What kind of debts can I discharge in a Chapter 7?
Well, the easiest thing to look at are going to be things like credit cards, personal loans, medical bills. Those are general unsecured claims, and unless there's something really unusual, those debts are going to be dischargeable in a Chapter 7 bankruptcy. You can discharge a car loan. You can discharge a home loan. You can get those things discharged, but if you want to keep the car, you still got to pay the loan. If you want to keep the house, you still got to pay the loan. So secured debts, while the debt might be dischargeable, the lien on the property is not, so you're going to want to continue to pay on those items.
So I can still keep my house and keep my vehicle if I file a Chapter 7?
Absolutely. I really want my clients to be current on their vehicle and current on their home at the time we file the Chapter 7 in order for them to be able to keep those items. And there's a process called reaffirmation that we will look at with people's vehicles for sure, and occasionally with their homes, that will essentially treat the loan as though no bankruptcy were filed against it.
How long does it usually take to get through the process?
Well, to get a case filed usually is a pretty short time. It can sometimes be a matter of days to get a case filed. To get a case to discharge is probably going to take about 5 months, maybe 6. And the case might not be completed at the time of discharge, and that's because there might be administrative work the trustee needs to do after the case is discharged. So the case might stay open, but my client doesn't have anything to do with that. That's a process that goes on in the court system. And it's going to be on somebody's credit report for 10 years, but it's probably only going to have a real negative impact for maybe a couple of years.
Are there any downsides to filing a Chapter 7?
Yeah, with everything that you do in the legal system, every kind of case that you file, there are also always kind of these negatives that you have to look at. One, the discharge in Chapter 7 is not as broad as the discharge in Chapter 13. So there are certain debts that I cannot get rid of in Chapter 7 that I probably can get rid of in Chapter 13. Those almost always involve divorce cases. Divorce cases are a big thing there. The other thing is that Chapter 7 is what I call the one-way street. Once you file a Chapter 7, you cannot voluntarily dismiss the case. You have to request permission of the court to dismiss the case. And most of the time, there's not a good reason to dismiss the case. Sometimes a client will come to me and they'll have some assets that are not protected by law, but they don't think they're worth anything. And they'll file the Chapter 7, and the Chapter 7 trustee will say, well, I know you don't think these are worth anything, but I want them. And the client doesn't want to give them the assets and does not want to pay for them. An example would be something like a comic book collection, a card collection, collectibles in general, maybe an extra vehicle that the client's not really using. And the client wants to keep these things, and the trustee will say, well, you got to turn them over. And then the client will come to me and say, I've changed my mind. I don't want to be in this Chapter 7 bankruptcy. And if the discharge has already been granted, the client thinks the case is done, but it's not. Remember, there are still some administrative things to do, and sometimes that means collecting the assets. I can't convert that case to a Chapter 13, and I can't dismiss it. So now the client is stuck in the Chapter 7. That's a downside.
What if, say, somebody files a bankruptcy and then they inherit some money immediately after?
Okay,
or within a couple months?
The 180-day rule. This is the 180-day rule. So if you file a bankruptcy and somebody dies and leaves you an inheritance within 180 days of the case being filed, that inheritance is pulled into the estate, and it becomes property of the bankruptcy estate, and the bankruptcy trustee is able to seize that inheritance for the benefit of your creditors. And the language is inheritance, devise, or bequest. But really we're talking about inheritance. So does that include something like a life insurance policy? No. If somebody dies and you get life insurance proceeds, I don't think that's going to fall into that category, but inheritance certainly will. And it's another one of the things you have to consider when you're planning a case.
What if I had some kind of, I don't know, cause of action against somebody else that I did not know existed when I filed a case? I think I'm talking about like maybe a mesh or a case or something like that, where something is discovered later. Who gets the money if the injury happened prior to filing of the bankruptcy, but the recovery happened way after?
Well, I think you get into if the injury was discoverable at the time that the case was filed. And in the mesh cases, there have been a number of mesh cases where funds have had to have been turned over to the bankruptcy trustee for administration in the bankruptcy case. One of the issues you get into when you file a Chapter 7 case is that if you have a pending lawsuit against somebody for medical malpractice, personal injury, medical device, that's what the mesh cases are. And for anybody who doesn't know, the mesh implant cases are usually hernia cases. So people that have had hernias had a mesh installed, and in some cases it went bad and the mesh had to be removed or replaced. But those are really medical device cases. And so people would have the mesh in them, and then they would file a bankruptcy case, and they would have already, of course, have had the surgery done and arguably already be having complications, but it wasn't to the stage yet where they were involved in a lawsuit. And the question is, when they're involved in a lawsuit later, did that cause of action exist prior to the case being filed, or did it arise after the case being filed? And I think in most of the Chapter 7 cases, that's property of the estate. You know, there still may be some fact issues you can argue where it's not, but if you have an auto accident, that's clearly property of the estate. And the bankruptcy trustee in the Chapter 7 case has the power to step into your shoes and seize control of that case. So they can settle that case when you would not have wanted to settle it.
Does that mean that, say, I think my injury is worth $500,000, my debts are $60,000, the Chapter 7 trustee can settle my case for $60,000?
Absolutely.
Yeah.
I think it absolutely means that. Now, I'm not telling you for sure they will do that, but I absolutely think they can do that. I think they're well within their rights to do that.
What are the upsides of filing a Chapter 7?
You know, Chapter 7 in a lot of specific cases makes a lot of sense. Where there's not a lot in the way of unprotected assets, where the debts are general unsecured debts, where you're looking to get out of a case quickly and you're not looking to make any payments. Chapter 7 probably makes sense because it's faster. And in some cases, it's cheaper, even though you pay the fees before you file the case. So Chapter 7 is going to have upfront costs, and you're going to have to pay a filing fee probably up front. But you might be out of bankruptcy quite a bit faster. Mm-hmm. And for some people, they may have something they're planned out 2 years down the road or 3 years down the road, and they don't want to be in bankruptcy because of what they've planned out in the future. And it comes up, we discuss it with people, but I like 7 when people don't have assets that can be seized, when they don't have unusual transactions that I have to worry about being clawed back. I like 7 to get people out quickly if I think it's actually going to cost them less money.
You mentioned that most of your bankruptcy attorneys will want to be paid before they file a case. Why can't a client make payment arrangements on that fee?
Okay, so there is a Supreme Court case about this, and essentially bankruptcy attorneys are treated just like the rest of the creditors in the case. And so if the bankruptcy attorney does work before the filing of the case and they're not paid for that work, then the fee they're owed on that work is dischargeable in the bankruptcy case. And most of the attorneys I know will not bifurcate or split their fees out. The bulk of the work in the cases, which is planning, drafting schedules, meeting with the client, going over things, the bulk of that work is done prior to the case being filed. And most of us, I think, are hesitant to not get the fees in advance. The other thing is, I don't want to collect from clients. Clients come here to get away from collections, and the last thing I want is to be in a position where I'm going to have to try to collect a fee from a client. So I don't split my fees up, one fee before filing and one fee after filing. Occasionally you'll hear about offices that do that. Sometimes it works out for them. Sometimes it doesn't. Sometimes they end up in a battle with the U.S. Trustee's office over whether they should be paid. And there are all kinds of problems with that. So we don't do that in this office. And I personally don't know any attorneys that do it.
Okay.
There's one other downside to Chapter 7 I want to mention.
Sure.
Well, I want to talk a little bit about that. And that's arguably, I mentioned a seizure on assets, but the reality is Chapter 7 trustees are put in a position where they're not really paid unless they collect assets or unwind transactions for the creditors in the bankruptcy case. Mm-hmm. So a Chapter 7 trustee, in a way, has this kind of encouragement to be very aggressive when it comes to assets that are not protected by law and transactions that can be unwound, because they're not going to get paid otherwise. They get a finder's fee out of the money they collect, and when they have to do legal work in the case, they can charge their hourly rate against the money they've collected. So they get both the finder's fee, and they get to charge their attorney's fees. Now, they're not doing anything wrong. That's the way the system is supposed to work. But what it means is that when you deal with a Chapter 7 trustee, you'll often find there's a level of aggression in terms of collections that might be higher than you would expect. Mm-hmm. So do we want to move on to Chapter 13?
Sure, let's move on to Chapter 13.
Can you tell us what's the basic idea behind Chapter 13?
Well, Chapter 13s are reorganizational bankruptcy. So a lot of times people who file Chapter 13s are trying to save a vehicle, maybe trying to save a house. Sometimes they want to protect assets that they would typically lose in a Chapter 7. Sometimes people don't qualify for a Chapter 7 because of the amount of money that they make, and so they have to make some kind of repayment to creditors. So there are different reasons for filing a Chapter 13. Chapter 13s typically last 36 months to 60 months. Unless you're paying everybody in full, you cannot get out of the case sooner than 36 months if you're a below median debtor. If you're above median, you actually have to stay in the case for 60 months and commit all of your disposable income to the repayment of creditors. Now, Chapter 13 does allow you to do some helpful things like perhaps reorganize your car loan. If you had the vehicle long enough, you only have to pay the value of it at whatever the interest rate the trustee is paying out, and sometimes that's significantly less than what you do or what you have outside the bankruptcy. You also can catch up on mortgage payments without having to worry about getting a foreclosure notice or your house being foreclosed on. A lot of times, even if you have to pay creditors back in full, you're paying them at 0% interest rate. So it will save you a lot of money in the long run. One of the, advantages of a Chapter 13 is that it's very flexible. It does take into consideration what kind of income is coming in the door, and not just at the beginning of the case, but also while you're in the case. So if your circumstances change, your payment potentially could be affected by that. Of course, if your circumstances improve, that can also be, that might mean a higher payment, for example, to the bankruptcy trustee.
Well, let me ask you a couple questions.
Okay.
Because now you're talking about a plan. Who proposes the plan to make payments into the case?
Sure. So the debtor and their attorney usually discuss the plan and propose the plan to the court in terms of repayment. The plan typically covers things like if your lawyer is going to get paid through the case, like if there are any other administrative expenses. It covers the trustee's fee. Trustee typically charge you a fee up to 10% of whatever payment you're making. So let's say if you're paying $100 a month, the trustee can charge up to $10 to administer the case. You can also include vehicle payments or mortgage payments in the case, depending on what's going on in the case, as well as taxes. Again, because Chapter 13 is so flexible, that plan is going to be really geared towards your personal financial situation and kind of see what you need to accomplish there.
Well, let me clarify. The attorney and the debtor are going to propose the plan, but the payments are going to be made to the bankruptcy trustee?
Correct. The payments are always made to the bankruptcy trustee, so you never, as a debtor, are making payments to your attorney or to anybody else, really, unless somebody specifically or your attorney specifically instructs you to pay somebody else. Let's say if you're paying your mortgage directly to the mortgage company, or say a vehicle directly to the car company for some reason. But generally, to take care of all your debt, you're paying your bankruptcy trustee, who is then administering the case, which means they collect the money and then disperse it as needed or according to the plan.
Okay, so if I understand this correctly, I'm going to have essentially two things going on. One, I'm going to have if I file a Chapter 13, I'll have my regular payments I'm making, like my utilities,
Rent.
my car insurance, rent, and that's going to be in kind of one pot. And then in the other pot, I'm going to have what I'm paying on my bankruptcy plan.
Correct.
That's correct?
Correct.
Okay. So you said plans can run generally between 36 and 60 months, and you mentioned the means test. So how do you determine the numbers that go into the means test?
Sure. So the means test is really just a formula, the formula that's written into the bankruptcy code that uses some median income and other expense calculations that are updated regularly. What that means is that your bankruptcy attorney has to look at the last 6 months of your income to see if you're above or below median for the area where you live. And then based on that, if you're below median, your commitment period, meaning that how long you absolutely have to stay in this Chapter 13 unless you're paying everybody in full, is 36 months. If your income is above the median, then you have to be in the case for 60 months. Now that formula is pretty cut and dry. There's some variations, there's some things that your attorney might be able to deviate from, but really a lot of the numbers are just kind of hard written into the code, and that's what determines how much you have to pay back your creditors, if any.
If I'm below the median, do I have to fill out the means test?
Yes, you do, but not all the way. So there's a short version of the means test and the long version of the means test.
If I fill out the short version, do I then still have to do a budget to determine my disposable income?
Yes, you do. So there's two things that control the amount you have to pay to the trustee. One of them is the means test. So it's kind of this formula, right? The government formula, if you want to put it that way. But the other one is just based on your actual, situation, your financial situation. So your actual income and expenses are absolutely taken into consideration. Think of it like some people might not have any expenses, like maybe they'll live with somebody, or something else is, their living expenses are just so low that they can afford to pay something back to their creditors, versus somebody whose rent is a lot higher, or perhaps they have dependents or whatnot. So there's different ways to look at the budget, and different ways to determine how much needs to be paid in.
Okay, so I'm going to give you an example. Let's imagine I am below the median, okay? I'm a below median debtor, and I come to you to file a bankruptcy, and we know my income is below the median. And let's imagine that I have my car, my attorney's fees, the filing fee, and the trustee's fee to pay. And we add all that up, and let's imagine that payment is, or the total amount that I've got to pay in, for argument's sake, I don't know much of my car. We'll say that I've got to pay in $12,000 to cover all those things. Mm-hmm. And you and I do a budget. And according to the budget, because I live with family and I pay a little rent there and I don't pay utilities, and I actually just got a better job, I make more money now. Mm-hmm. Let's imagine that my budget says that I have $400 a month left over. So theoretically, I could pay my 12 grand off in 30 months. Am I still going to have to go 36 months?
Yes, you do.
What happens to that extra 6 months of payments?
Mm-hmm. So the extra 6 months of payments is going to go towards your other creditors that we don't necessarily have to pay in the case, but will be paying if we have the money available. So things like credit cards, medical bills, personal loans, things like that. So your budget or your payment in a Chapter 13 will absolutely depend on how much money is coming in the door and what's getting out of the door.
Okay. Let's go back for a second. Let's imagine that I didn't have to pay $12,000. I had to pay $20,000 in, and I still have the same $400 available, but now on paper it looks like it's going to take 50 months to pay that back. Mm-hmm. Does my case get extended to 50 months?
It can. So if there is cause, you can always extend the case beyond 36 months. And if you don't have enough money coming in the door to be able to pay everybody in 36 months, that's sufficient cause to extend your case up to 60 months. Remember, you have 60 months to complete all the payments that you want to pay under the plan. Now, there is some 10th Circuit law that makes that 60-month deadline kind of like a hard deadline, meaning that you really, really need to complete your case in 60 months. There will be no 62 months, for example, unless there are some special circumstances. But so you have to be really careful about getting things done, within that 5-year period of time.
So let's imagine that we're doing the budget, and I am contributing to retirement, can I continue while I'm in Chapter 13? Can I continue to contribute to retirement?
Absolutely. Yeah, you can absolutely continue contributing to the retirement. There are other things you can also do. Now, that might be jurisdiction specific, but I know in Kansas, and I think Western District of Missouri as well, the retirement is not an issue, and the court will allow you to continue contributing to 401k or an IRA up to a certain percentage. Like, I don't think you'll be able to put all of your income into that. That's just not going to be fair, but I think like 7-10% is probably okay, especially, depending on your age. And the amount of retirement savings you have, which unfortunately a lot of people don't have a lot of. We have a lot of clients who come in with, I don't know, nothing in retirement because they already tapped into it trying to pay debt. So,
if I'm paying my car through the bankruptcy, am I going to pay the interest rate on my car loan, or am I going to pay a different interest rate?
That depends. So, depends on what your interest rate is, and also depends on how much we're paying for the vehicle. If you've had the vehicle long enough, like about 2.5 years, or if the vehicle's been refinanced, you only have to pay the value of the car in order to keep it. Now, that interest rate will be determined by till rate, which is what the trustee sets out as the interest rate to be paid. Right now, that rate is like 9.25%, but in the past, it's been as low as 4.75% or 5%. Again, that's kind of tied into the federal interest rate. Now, if you've just purchased the vehicle, say within the last 6 months or 6 months to 2.5 years, you have to pay whatever you owe on the car, so the entire principal balance. Now there, the interest rate could be contractual interest rate if it's lower than the till rate and if your lender does not object, or it can be the trustee's interest rate. The worst case scenario is the trustee's interest rate you're paying in full if it's a 910 car, meaning that you got it within the last 2.5 years and it has not been refinanced.
So when I file this bankruptcy, the automatic stay comes into effect?
Correct. The automatic stay comes into effect immediately, whether you file 7 or 13. And for the duration of the bankruptcy, whether it's 7 or 13, it stays in effect. So in theory, even if you have new debt, for example, you got hurt, went to hospital, they're suing you, you're in a Chapter 13, guess what? They cannot garnish your wages because your wages or any earnings you have are part of the bankruptcy estate, and they're protected by this automatic stay. So there are some advantages to filing a Chapter 13, in that regard. But one of the main things, I guess, or one of the biggest advantages of Chapter 13 is that it's voluntary. So say if you do inherit some money and you decide that, hey, I no longer need a bankruptcy, or I just want to pay everybody off, or I want to settle things, it's going to be cheaper, you have that off option, meaning that you can ask for the case to be dismissed and then you're just done. Things go to the way they were. There's no requirement that you have to stick it out or that the trustee has to come after any assets or anything like that.
Do creditors in Chapter 13 have a limited amount of time to file a claim to even have a chance to get paid in the event there was an inheritance or something like that?
Sure. So creditors in Chapter 13, unlike 7, when I think they're waiting for notice of assets, meaning the Chapter 7 trustee found something to divvy up among everybody, in a 13, they have 70 days from the time we file a case to file something in the case in order to get paid later. So if they miss that deadline, for example, they thought, I'm never going to get anything out of this case, and they decide to miss that deadline, they cannot come back later and ask to be added. But that also means that if you forgot to list somebody, you might be out of luck and they might survive the bankruptcy as well. At least that's how it is in the 10th Circuit or Kansas.
When do you get a discharge in a Chapter 13 case?
So you get your discharge in a Chapter 13 case after you completed all of your planned payments. That typically means you've been in the case between 36 months, 60 months. You paid off the things that you wanted to pay, say your attorney, filing fees, trustees' fees, maybe taxes, vehicle. And then you actually stayed in the case for the 36 months that you needed to. Once that notice of plan completion is filed by the trustee, your attorney will actually file a motion for entry of discharge. At least that's how procedurally things work in Kansas. And you get your discharge. By the way, in a Chapter 13, if you're paying the vehicle through the case, you cannot necessarily get a lien released until the case is done. So, but once it's done, your creditor should be able to send it to you very quickly.
Okay, well, I think that covers a lot of information about 7 and 13. Obviously, every case is unique.
Is unique and
they're
different,
all
yeah.
unique and they're all different. And these are it's very general information we're giving out. If you have questions about your specific facts, please reach out to us. If you need to stop creditor calls, harassment, collections, lawsuits, repossessions, garnishments, or foreclosures, please give us a call. Consultations are free.